great to have you all on board. It's another time with Futo.io, the enthusiastic Futo, and in today's tutorial, we are going to be taking the course ACC411. It's a course for the department, for the Faculty of Management Science, under the Department of Accounting. It's been an interesting one. We've been talking about auditing and who an auditor is expected to be, all right, the ethics, the standards, everything that has to do with how we go about executing his profession. And we've been talking about as well those that offer assurance services. We've been considering the legal part of their job and what is expected of them generally. So it's going to be a continuation of that in today's class, but we're going to be very particular about the case law, all right, under ACC411, considering how certain situations are handled by the court of law between the auditor or firm offering auditing service and their clients. So this being said, straight into it. For those of us who haven't joined the private class, very important to join the private class. All you need to do is just reach out to Futo.io on www.futo.net, which you use the WhatsApp button at the top right corner, send direct message. Take it up from there, guide different processes. So let's hop straight into this class. So we have ACC411, and we're going to be talking about case law. Now, like I said earlier, I'm going to be considering certain cases, okay, that certain cases of dispute between the auditing firm and their clients. So to start with, for tonight's class, we have the case of London, all right, and General Bank of 1895. Okay, 1895. Now, the fact about this case, okay, before the fact, we're actually supposed to, okay, so the fact about this case, all right, the bank had advance loan to customers backed with insufficient collateral. So it was a case of a customer using insufficient collateral or securities. We call them securities or collateral to secure a loan. I know when we talk of security or collateral in the process of securing a loan, it's very important because in the case or issue or situation whereby the party requesting for the loan defaults, the bank can always, all right, have the collateral sold and get their money back. So now the bank took credits for interest accrued on those loans and paid dividends out of what we call spurious profits in variable out of capital. Now, the adequate provision was not made for bad debt and non-performing credits. Now, this is it. The auditor in this case, definitely the loan securing side, the individual, all right, the bank's auditor did something here. The auditor apparently was aware of the real state of affairs that the banks, all right, the bank that loaned to customers backed with insufficient collateral, the auditor is aware of the real state of affairs and reported fully to the directors who refused to alter the accounts. Now, in his report to the shareholders, the auditor made no mention of the deficient security. Are we together? When this auditor was, I made mention of this earlier in this course. I said, whatever the auditor says about the financial position or security or what have you of an organization cannot be reviewed by anybody. Why? Because the auditor has the final say. According to standard, according to the ethics of the profession of auditory, they are to work without influence. They are to work without bias. They work objectively based on numbers. So whatever they say is not questionable. It can be questioned, but most likely you don't want to question them because that's why you are employing them. That's why you are paying them for them to give you the actual figures. And when there's errors, can be corrected. Now, but merely stated, the values of the assets shown by the balance sheet is independent upon realization. Now, the bank failed, and one of the principal reasons for the failure was the heavy loss in respect of these loans. Now, what is the judgment of the court or the judgment of the judge? So we have held. When we say held, so we've talked about the fact. When we have insufficient loan securities. All right. So we have the judgment known as held. Auditor was guilty of what we refer to as misfeasance, and this jointly and thus jointly and severally liable with directors in respect of 2 dividends cleared, amounting to the sum of £114,000 on the ground that they both have to report the full fact to the shareholders. Okay? Now, bank don't own those money. Those money belongs to the shareholders. What we say shareholders? These are people that have money in a particular organization. So they become a part of the owner of the organization. So unfortunately now, because of this bad business, the bank lost their money. And it was as a result of the fact that the auditor did not do his job well. And even after reporting this false information to the director, they still did not question it. All right. So both the auditor and the director were held responsible. So now it says here that the auditor was guilty of let's just refer that to as misinformation. All right. Okay. Misinformation. And liable with the director and liable with the director. Okay. Liable with the director in respect of 2 dividends declared. Director in respect of two dividend declared. Okay, so we have that as that. Now that's the case of we, right, London and General Bank. So let's take one or two more of them and can proceed. Now we also have the case of Headley Brain. Okay, we also have the case of Headley Brain. Excuse me. Currently having cold. Just permit me. It's quite a bit challenging here. We just have to be the needful, irrespective of the situations that surrounds it. So now we have Headley. Headley. Let's just leave that. Headley Brine. Headley Brine Code. All right, Company Limited. All right, a corporation limited. Anyone, CO, and we have limited versus Hila and Partners Limited. All right, we have Hela and Partner Limited. In 1963. Now, what happened in this case? The fact of the case, we have the plaintiff who happens to be Headley. Who is a plaintiff? A plaintiff is a person who brings a case against another in a court of law. Okay? Now, the plaintiff, the person suing, is Headley. Now, the plaintiff, which is Headley, lost money when a bank reference was negligently produced. So we're talking about fact of the case. Headley lost money due to the bank reference. All right, bank reference. You want to talk about reference? Reference is more like a collateral in person. All right, a collateral now or security would be a property or documents that can be converted into valuable. But when we talk about reference now, we're talking about people that have, all right, reputable people that can stand in for you. So now, in the case of Headley, money, he lost money when bank reference was negligently produced. Now, the bank indicated that their client was a good credit risk, meaning that he has been taking loan from time to time and he has been paying. All right. So let's say probably now you take loan of about 500,000 before, based on your relationship with the bank. So there is a time now you want to expand. A time comes whereby you want to expand your business. So from 500,000, all of a sudden you increase it to about 5 million naira. You want to get a loan of about 5 million naira. So you know that the excuse me, you know that the processes, the documentation will be different. All right, but based on his good credit history, according to the bank, says that their client, which is Headley, has a good credit risk. All right, So the bank indicated that their client was a good credit risk when this was not the case. Now, this is a bank standing in as a reference for a particular customer. Okay. Now, the bank is saying that this customer is a good credit risk, and that was not the case. That's why it says negligence. So this could be, it's not even a matter of could be. Why will a bank stand in based on false information or false pretense? Now, let's take this is a disclaimer, like we do on this stream. We don't encourage false information or instigate things on false pretense. What we do here is basically purely educational. All right? So please note that. So now this bank says, okay, our customer, our client has a good credit, which is a lie. Now, held, the judgment in this case is that in principle, though there was no contract between Edley and the bank that stood in. So now, Edley wants to take money from these people. So his bank now is now saying Edley here has what we call good credit score, or has what we call good credit risk. So these people like, no, if the bank can say Headley is doing this, that means you can borrow Headley money. And that was not the case. So between Headley and the bank that gave the false information about his credit risk, there was no contract between them. We are talking about the health now, the judgment. All right. Therefore, the bank was liable to pay for damages of its negligence. So Edley is not being held responsible. Who are being responsible? The bank that gave the false pretense or false information about its credit risk. Are we together? So the key point here is that if a third party could show that it relied on the work of another, all right, which is the auditor, which turned out to be wrong, the third party could claim damages. And this is the third party here. So it was the case of the bank. It could be the case of an auditor too. So if an auditor is giving, okay, this is this number, and if it is wrong, the third party involved can sue the auditor. But in this case, the bank is paying for the damages. Are we together? That was what happened in the case of Henry Bryan Co. versus Hella Partner Limited. A lot of other facts are here, but let's just stop here for now, and let's go to some other things. Okay, so like I usually say, what we do here on YouTube is just about 30%, as we have the remaining 70% restricted to members of our private class. So if you haven't joined the private class yet, it might interest you to enroll today. And all you need to do is just visit our official website, www.star.net, where you find the WhatsApp button top right corner. Use that to send the direct message, and from there, take it up. So let's take the last case for tonight. I so much love this course because it talks a lot about reality. Okay. Now, let's see the case of Credit Alliance versus Hawthorne Anderson. Credit Alliance versus Hawthorne Anderson. So now, what do we have? The case tries to establish if an auditor may be held liable in the absence of privity. What do we mean by privity? In the absence of contract. If there is no particular contract, can the auditor be held responsible? We are about to find out. Okay, now held responsible in the absence of privity of contract, no binding contract, no legal contract, to a third party who relies on his detriment upon a negligence prepared report. So, if an auditor prepares a wrong report based on negligence, and there is no privity contract between auditor and the person in question, what is the case? Now, in reference to this, let's consider this case law. Credit Alliance versus Arthur Anderson. The facts of the case. The plaintiff, Credit Alliance, so this is the person suing Arthur Anderson. The plaintiff, Credit Alliance, were providers of credits. They give loans. All right. They gave loan to LB Smith to finance its capital intensive enterprise. Now, in 1978, Credit Alliance advised Smith that as a condition to extend further credit, they require their auditor financial statement. Now, this Smith now, for you to get more loan from us, they advised Smith that you need to bring your auditor's reports about your enterprise. How much are you making? In 1978, okay, like I said earlier, now Smith provided their 1977, that's a year before, financial statements. All right. The certificate is it provides a certificate of the financial position true and fair by Otto Anderson. Now, Smith is not the owner of Otto Anderson. And Smith here, because he wants to get money from Credit Alliance, provided the financial position or financial statement of Otto Anderson true and fair by their own auditor for Credit Alliance. Are we getting it? Now, on the strength of these financial statements and those of 1979, on further request by the plaintiff, Credit Alliance provided substantial amounts to financial LBC. So he was able to get it based on the documents he provided. It was alleged that both statements overstated Smith's assets. Excuse me. Oh, my apologies again. Now, based on the false information, they have just to get more loan, Smith's assets were overstated more than what it's expected to be. All right. The net worth and general financial health, and that Anderson failed to conduct investigation. All right. So, for Anderson to provide Smith their financial position, Smith also gave Anderson some documents, and the documents Anderson received from Smith. All right. Perhaps you might be wondering, why will Anderson offer their financial position to Smith? Because Smith has gone to overstate his net worth and assets. So now Anderson is now being held responsible for not doing the proper checking before giving Smith their own financial statement. So they are being held responsible. Okay. So now the case will end there. You now believe that in 1980, this same Smith that overstated his net worth and assets now filed a petition against Credit Alliance. All right. That Smith filed a petition of bankruptcy. Credit Alliance instituted an action against Otto Anderson for damages on its loan losses. Now, look at how it works here. Now, Smith filed a petition for bankruptcy. I mean that I cannot pay back the loan, money I collected, it was not successful. I could not implement the business successfully. So I cannot pay the money back. So he filed up a petition for bankruptcy. He does not make money with the loan and he's not paying back. Now, Credit Alliance here, who is the organization that provided the loan, now has to, all right, Credit Alliance instituted an action against Anderson, also Anderson, all right, for damages on its loan, alleging negligence and fraud. Can you imagine that? So, call it wrap here for today. Thank you very much, everyone. It's a very interesting course, and we'll take more case law in our next class, and we'll move to some other things entirely. Okay, so let me just highlight this so I can know where to start my next class. Okay, so let's ensure to submit our notes to the appropriate content. I look forward to seeing all the subsequent tutorials. Bye for now.